The court was very specific, and we bring this up in class every time we teach. The court was very specific to use the phrase reasonable officer when they could have easily said a reasonable citizen, like a reasonable person, right? We want to judge these through the lens of a reasonable person, or a reasonable attorney, or a reasonable judge. But they specifically said police use of force cases must be judged from the perspective of a reasonable officer. And that's clearly an acknowledgement that officers have training and experience that makes them see things in a different way.
You're listening to Precinct 444, a podcast network from the National Law Enforcement Museum. Today we're bringing you an episode from Law and Disorder, where we dive into the world of true crime stories with memorable cases that have lasting effects for law enforcement.
Hello, and welcome to today's episode of Precinct 444. I'm joined today by Jim Balthazar and Paul Massock, both of ATF, who are widely considered to be law enforcement use of force policy experts. This pair often hosts training sessions for media professionals to help them better understand why law enforcement uses force when it's necessary, and how to best report these incidents to the public when they do happen. So today, Jim and Paul are bringing their expertise to our studio to provide you, our listeners, with a crash course in law enforcement use of force policies. They've wanted to bring their knowledge to the general public for a while, so where better to do that than the National Law Enforcement Museum? Please join me in welcoming Jim Balthazar and Paul Massock. So welcome.
Thank you.
Thank you very much.
Yeah, of course. And thank you both so much for being here. I understand this is the first podcast you've ever been on, so we're really glad to have you. And to get started, why don't you briefly introduce yourselves to our listeners?
So I'm Paul Massock. I'm currently a Deputy Chief in the Special Operations Division for ATF. I've been with ATF for 33 years. I came straight out of college, actually swore on my 22nd birthday, which is pretty honorable, a nice blessing. I have had a pretty full career. It's been mainly focused in the field as an agent and as a supervisor in the field on firearms-related violent crime and firearms trafficking, kind of the bread and butter of ATF agents. But starting early in my career, I got involved in our special response team program and in instructing use of force, firearms, hand-to-hand, things of that nature. And throughout my career, I've gotten a number of certifications, mainly while I was at the ATF National Academy, where I was for 5.5 years, where I was responsible for all of the use of force training for our trainees going through the special agent basic training. Now in the position that I'm in, I am responsible for all of the training for the agents that are in the field in regards to use of force training, firearms, et cetera, as well as I oversee our entire special response team program, from equipment to training, selection, operation, review of op plans, all of those types of things. And then one other position that I held that has been influential in the topic that we're going to talk about is I was the chief of our force review office for a number of years at ATF as well, where we were responsible for reviewing all of the use of force incidents that ATF agents were involved in and determining whether or not they acted in accordance with policy.
My name is Jim Balthazar. I retired from ATF at the end of 2022. I spent just a hair under 25 years with ATF. Again, just like Paul, started as a field agent, a criminal investigator on the street, working firearms cases, some explosives cases, some narcotics cases. I did a little bit of undercover when I was a younger street agent, but also got involved in our special response team program pretty early in my career. I think I'd been on the job about 3 years when I joined the team as a part-time member, and did that for 7 years, and then went full-time to our special response team in Dallas. Did that for 10 years, was one of the snipers on our team. Also served as an instructor, guest instructor at our ATF National Academy, at other SRT-related trainings. And then I came up to headquarters as a supervisor in the ESF 13 branch, which most people have never heard of, but it has to do with law enforcement response during FEMA-related national disasters. So I did that for a couple of years, and then I moved into the public information officer position which was the first ever PIO position that Special Operations Division had. And I did that for the last 3 years of my career. So I retired, and now I work as a contractor for ATF to continue teaching this course that Paul and I teach. I'm also a contractor with Homeland Security, teaching active shooter. I'm an adjunct instructor at the University of Tampa. And then I have my own company as well called Panthera 7, where we do security training and consulting and things like that.
Very cool. And as I mentioned a little bit in the introduction, and you kind of mentioned this as you introduced yourselves as well, you teach this course about law enforcement use of force to law enforcement agencies, but also to members of the media. And now in a platform kind of like this, you're bringing it to the general public. How long have you been teaching these seminars, and what makes them so important?
So we started teaching this class in September of 2020. Actually, we had just developed the course earlier that year, and the course was aimed at teaching basic use of force principles and what the rules are, what the laws are regarding police use of force. And the course was designed to be taught at a citizens academy. Like many law enforcement agencies, ATF puts on citizens academies around the country. But for those people that remember, starting in the spring of 2020, we had the COVID-19 lockdowns. So we weren't really doing citizens academies then. So we kind of put this class on hold. And then 2020 also had a number of very high profile police use of force incidents, George Floyd case being the most obvious of those. And that summer led to a lot of rioting, a lot of civil unrest. And what we noticed during the coverage of these events, we noticed that there seemed to be kind of a lack of real understanding of the rules about police use of force by people who were reporting on it, whether that was professional media or people obviously on social media, citizens. They just didn't, they were commenting on these events in a way that showed they didn't really understand some of the nuances or some of the fundamentals about this. And so we decided to take this class that had been designed for citizens and to try to present it to media professionals. That was our way to get to the public, to try and train the public. The public's too big for us to train everybody. But if you could, our philosophy was, if we can better educate the media about the rules of police use of force, then when they cover these stories, they will be better educated and have a better foundation from which to ask questions of the people involved. And they'll be able to present a clearer, we think, more accurate story to the public. So that was our goal, was to educate the public through the media about police use of force. So we've been doing it for a little over 4 years now.
Excellent. And on podcasts like this is a great way to kind of get direct from the source, which is really nice as well. So I'm going to kind of let you guys have the floor today and kind of give us a taste of what that course looks like. This is your opportunity to present your knowledge to the general public on giving us kind of that crash course on law enforcement use of force that as it was first intended to be taught. So
again, as I said, it was intended for the media, although we have done some citizens classes as well. We've done this in over 40 cities around the country now, and with very great response from the media. I mean, the professionals, media professionals we've talked to have really been very receptive and really welcomed the chance to have this training. But we kind of break the class into a couple different parts. And the first part is that we set the ground rules by talking about the legal foundation of these policies. So I'm going to let Paul talk about that.
Okay.
So we talk about the two main cases that form the basis of the constitutional standards for law enforcement officers using force in the United States. The first case is Tennessee v. Garner. It is a case where an incident occurred in 1974, but the Supreme Court didn't issue their ruling until 1985. And in that incident, an officer was responding to a burglary. He went to the back of a house. He saw an individual running out of the back of the house with some items in their hand. He was going to be unable to capture them before they were climbing a fence and going to escape. So he drew his firearm and discharged one round, struck the suspect, and killed them. That ended in a lawsuit that made its way all the way to the Supreme Court 11 years later. And the Supreme Court gave law enforcement some strong guidance in regards to the use of deadly force. In this case, focuses solely on the use of deadly force. And what they said was that the use of deadly force to prevent the escape of all felony suspects was constitutionally unreasonable. And that's because in 1974 in Tennessee, that officer complied with his department's training, he complied with his department's policy, and he complied with state law when he used deadly force to prevent the escape of that felony suspect. And the Supreme Court said that's unacceptable. And looking at the use of force and analyzing it through the Fourth Amendment, which prohibits unreasonable search and seizure, they said that the use of deadly force must be reasonable on the part of the officer. And they gave two general examples when the use of deadly force would usually be deemed reasonable. And those would be first, for an officer to defend themselves or another. And they said that if a law enforcement officer, if their life or the life of another is threatened by a suspect with a weapon, generally that's going to be considered an acceptable or reasonable use of deadly force. But what the case really focused on was preventing escape of a felony suspect. And so the rule that they laid out in this case in 1985 was that an officer had to have probable cause to believe that the suspect has committed a crime involving the infliction or threatened infliction of serious physical harm. So they added a harm component in regards to this rule, which did not exist in 1974 under the department policy that this officer was in compliance with. They added two other things. They said that the use of deadly force must be needed to prevent their escape, so you can't just shoot anybody that's fleeing the scene of a felony. Mm-hmm. And lastly, they said that a warning should be given prior to the use of deadly force if feasible. So this really set the groundwork for the use of the Fourth Amendment as the underpinnings of an assessment for use of force by law enforcement officers. Okay. The next case, the seminal case for officers using force, is Graham v. Connor, and that was decided in 1989. And that is an incident where an officer observed a vehicle quickly pull up to a convenience store, saw a passenger get out of the vehicle in the store for a short period of time, come back out quickly to the vehicle, and the vehicle quickly drive off. The officer decided to stop the vehicle. Why do you think they decided to stop the vehicle?
Well, if they're moving very quickly, everybody seems kind of in a rush. It seems like it's got a good idea that it's a getaway. Like
a getaway from what?
From a robbery.
Potentially, yes.
Yeah,
so
potentially
exactly.
A getaway from a robbery, yeah.
Yeah, so the officer observed things that he believed were consistent with potentially a robbery, clearly a crime. Mm-hmm. And so he decided to stop the vehicle and conduct what's called an investigatory stop. He's going to ask two questions. Did a crime actually occur back at the convenience store? And did these guys do it, if in fact it did? So when he stopped the vehicle, the passenger got out of the vehicle, was running around the vehicle, not following the officer's command. The officer had to use force in order to be able to apply handcuffs and detain the individual to conduct his investigation and cause some minor injury to the suspect. So from the perspective of the two people that were inside the vehicle, the passenger was experiencing diabetic emergency. Okay. And he'd asked the driver, his friend, drive me to the convenience store. I need to get some orange juice. Mm-hmm. So the driver reasonably quickly drives to the convenience store, doesn't take the time to park, just lets his friend out, who quickly goes inside, grabs some orange juice. He sees that there's a long line of people. He feels that he doesn't have time to wait for the line to finish. He sets down the orange juice, quickly goes back to his friend's vehicle and says, take me down the street to a friend's house. I'm going to get some sugar there, right? So his friend, again, reasonably drives off quickly, right? Because you would if your friend was experiencing an emergency. So when the driver sees the lights turn on and hears a siren, what does he do as a good citizen? He pulls over. His friend is now experiencing a medical emergency, is unable to follow the commands of the officer. The officer uses force, causes some injury, and now the passenger's upset, right? Because in his mind, everything that he and the driver have done has been reasonable. So from the officer's perspective, does his action sound reasonable?
The officer's actions do not. No.
No?
Well, I don't know. So from like knowing the context of it, like what the officer would be thinking is going on, yes, it is reasonable. But from the perspective of the passenger, probably not.
So this is what the court had to balance out in this case is, okay, from the officer's perspective, he's acted reasonably. He saw actions that he thought were consistent with a robbery, so he's going to investigate, which is exactly what we want police officers to do in society. That's their role. If they see what they believe to be a crime, we want them to intervene, right?
Yeah.
From the perspective of the driver and the passenger, they've acted reasonably, right? This officer has ended up causing injury to somebody unnecessarily from their point of view. So these two perspectives crash head on into each other. So it's a wonderful case for the courts to take a look at, right? So the courts come up with a few very key decisions and points that they make in this unanimous decision, by the way. So this is a strong statement by the Supreme Court that these are the rules we expect law enforcement to follow. So there are a lot of unanimous decisions at the Supreme Court, but when you look at unanimous decisions about a Fourth Amendment issue regarding police use of force, much rarer. So this is a strong statement by the court. So the thing that they do here is, again, they confirm what Tennessee v. Garner said, which is you're supposed to analyze these incidents through a lens of the Fourth Amendment. Were the officers' actions objectively reasonable? So they added the word objectively, which did not exist in the Tennessee v. Garner case, which means what they're looking for is articulatable facts. And when I told you the story about what happened with the officer, I gave you very clear objective facts as to what he saw. I didn't subjectively say the officer saw actions that he thought were consistent with a robbery. We talked about the specific things that he saw, facts, right? So they said, we need you to articulate facts to support the reasonableness of the force that you've used. They also make clear in this decision that their decision covers all uses of force, from the least amount of force, just a simple touch, all the way up to the use of deadly force. So this is the seminal case. So they've established objective reasonableness as the linchpin here. And when it comes to reasonableness, they tell us that the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene. So we just talked about perspective. Whose perspective is the one that the court is going to side with? And here they make it very clear they're going to side with the perspective of a reasonable officer. What facts could an officer point to articulate that his actions were reasonable? But they also talked about a few other things. They said that you cannot judge with the 20/20 vision of hindsight. Now, when we talked and I asked you if you thought, why you thought the officer stopped the car, you said,
probably a robbery.
Yeah. So his perspective and the objective facts that I pointed out to you, you drew the conclusion, hey, there may have been a robbery here. But then when I talked to you about the perspective from the driver and passenger's point of view, now you became a little more concerned, right?
Yeah.
Well, is this really going to be reasonable now that I know these additional facts? So the court said, you can't take into account facts that you learn afterwards. There's no 20/20 vision of hindsight when analyzing whether the officer's use of force was reasonable. So the officer didn't know all the facts that I gave you after we talked about him conducting the stop. So they said no 20/20 vision of hindsight. So there's just like two other things that the court said that are very important for us to understand. One of them is that the court recognized how difficult the job is for police officers and how high the stakes are. They said that allowances must be made for the fact that police officers are often forced to make split-second decisions. These things happen very, very quickly in incidents. Here at your museum, there's a lot of incidents that you guys talk about. There are a lot of, reenactments that you can watch and things of that nature, and you can see how quickly these things develop. And all of us in our own lives have seen enough video and heard enough stories to recognize these things happen very quickly. So they said we have to make an allowance for the fact that officers are forced to make split-second decisions. And they said because these circumstances are, and the words they use are tense, uncertain, and rapidly evolving. We've already covered the rapidly evolving part. Tense are use of force incidents and interpersonal violence between people. Tense?
Yes.
Yeah, they're high-stakes events, aren't they? Mm-hmm. Yeah, we're talking about literally about people surviving an incident or perhaps not, getting seriously injured or not, right? So they're clearly tense. And by saying that they're uncertain, what they're telling us is that the end of the event, the result, is not known until it's over. So during the entire incident, if you're the officer, you don't know if you're going to be injured or not. Mm-hmm. You don't know how hard this suspect is going to fight or what force you're going to have to use to overcome their resistance. So they've basically said with that, the job's hard and we recognize it and we have to give some allowance for that. So all of this hinges on this word reasonableness, mm-hmm. right? Because we talked about it both in Tennessee v. Garner and we've talked about it here in Graham v. Connor. And a lot of people ask us, well, okay, so what are the rules? When can you use force? Well, you can use force when it's reasonable. And the court here says that the test for reasonableness under the Fourth Amendment is not capable of precise definition. So they've given us this linchpin concept of reasonableness, but they won't define it. They've essentially said, we'll know it when we see it. You've got to articulate it through the objective facts you present to us. And the other part of it that they say is it's not capable of mechanical application. So that goes back to when people say, so what are the rules? When can an officer shoot somebody? Well, they can shoot somebody when it's objectively reasonable. And that's an unsatisfying mm-hmm. answer to some people because it would be much easier if we had this set of rules that said, if they're doing A, B, C, and D, you can shoot them. If they're doing E, F, and G, you can use a taser, mm-hmm. but those things don't exist. The courts have given us the concept, and it's our job in law enforcement to learn to apply those in a reasonable manner.
That makes sense.
That's the short legal lesson. So to summarize all of that together, here's what the courts say the legal rule is. Based on the totality of facts and circumstances known to the officer at the time they used force, was that force reasonable? From the perspective of a reasonable officer on scene, without the benefit of 20/20 hindsight, and giving allowances for the fact that the job is tense, uncertain, and rapidly evolving.
And that makes a lot of sense. And but this is also one thing that kind of goes along with this that I think the public needs to consider is each department's going to do it a little bit. They have to fit those rules, but do it with the resources they have. So how does that happen? Where do they get started?
Sure. Excellent question. So how do you get started in creating policy? Mm-hmm. The first thing you have to do is understand what the law says. So what I've given you is the constitutional standards. This is what the Supreme Court has told us in law enforcement the legal rules are.
Okay.
Now, the department is going to set policy. So think of the constitutional standards as guardrails on a road when you're driving down mm-hmm. the road. Right? We have those guardrails there because if you go past them, you're off the road, clearly in an accident, right? Think about policy as the yellow lines that are on the road. Now, each department sets its own yellow lines, but the guardrails have been established by the Supreme Court. So how wide or narrow do we want to place those yellow lines on the road? Well, each department will decide that based upon, how much liability do we want to try to protect our officers from? We don't want them to get too close to the guardrails, so we're going to bring those yellow lines in a little bit. Additionally, what are the expectations of the citizens in the community that they serve? What do they believe the rules are? So an important takeaway from that is an officer can violate policy, but not violate the constitutional standards. For example, in the Eric Garner case in New York, the officer was accused of, do you remember?
Refresh my memory a little bit. And this also refreshes the memory for our listeners too.
Sure, absolutely. So Eric Garner was selling loose cigarettes in New York. Officers came up to him and confronted him about selling the loose cigarettes, and they end up wanting to arrest him for that offense. Okay? So one of the officers is accused of utilizing a chokehold when he goes to arrest Eric Garner, a very large individual. That chokehold was a violation of NYPD policy, but not necessarily a violation of the constitutional standards. So when the conversation takes place in the media or in society, there can be this conflation between those two issues where people would say, wait a minute, the officer violated policy, so he clearly violated the law. Not true. Two different standards, policy standards and constitutional standards. Violating the Constitution is a legal problem. Mm-hmm. Violating policy is an administrative problem for which you can be fired, right?
And that makes sense. All right. So now that we've got our kind of legal precedent, what are the things that we should know about a department's use of force so that when we see a story from our local department on the news or something like that, like help us to understand the information that we're getting when we're being told about an incident like that?
This is a great segue into Jim's portion of the class.
Exactly. Yeah. There you go.
Where after we've talked about the constitutional standards and what the legal rules are, Jim takes some time to explain to everybody what can be expected as far as human performance standards go. As I talked about, tense, uncertain, and rapidly evolving. These are volatile situations where human performance under those stressful conditions matters. What can we really expect from officers' performance? They're humans, right? They're not TV characters. It's not the movies. Not every police officer is a karate expert, right? So,
and everybody reacts to stressful situations differently, even if you've been trained to react to them in a certain way. So,
absolutely. So, at this point, I'll turn it over to Jim.
Well, thank you. Yeah, that's what we want to talk about. That's exactly the point when you asked what should people take away when they're watching these events on television news or in social media or even just reading about them. But they're much more vivid, of course, when we see video. And now, thanks to the fact that everybody has a video camera with them all the time, let alone body cam footage on officers and dash cam footage and security cameras on buildings, very few events happen that there isn't some sort of video of. So it's important to understand, we want the public to understand what those rules are. Paul talked about it. But it's also important to understand the mechanics of it, because just because you understand the legal aspect of it, when officers are out there on the street and dealing with suspects, it's not a legal debate. It's not a legal conversation. It's often a fight. And so you need to understand the legal foundation, but there are more things that come into play when you're talking about two people fighting, certainly fighting for your life. So I want to go back to one thing that Paul talked about in Graham versus Connor, where the court mentioned very specifically that the incidents need to be judged, these use of force incidents need to be judged from the perspective of a reasonable officer, because that leads into what we're going to talk about that has to do with training and so forth. The court was very specific, and we bring this up in class every time we teach. The court was very specific to use the phrase reasonable officer when they could have easily said a reasonable citizen, like a reasonable person, right? We want to judge these through the lens of a reasonable person, or a reasonable attorney, or a reasonable judge. but they specifically said police use of force cases must be judged from the perspective of a reasonable officer. And that's clearly an acknowledgement that officers have training and experience that makes them see things in a different way. When someone puts their hands in their pockets, most people in America, if they're at their job and they're talking to somebody and the person puts their hands in their pockets, most people don't freak out, right? That happens all the time. But for police officers, it's a big deal. Or if somebody lifts up their shirt and reaches into their waistband for something. For most people, that isn't necessarily considered threatening, but for officers, it is. So the court acknowledges that. So now when we get into talking about these physical realities of violent encounters, we have to understand, first of all, that element of time, how important that is, how quickly things happen. The court acknowledged that also when it talks about these events are split-second decisions. Officers have to make split-second decisions in cases that are rapidly evolving. All of that is a reference to how quickly these things happen and how important time is. So we talk about things in the class like, I don't want to go into a deep dive about the OODA loop, but we talk about the OODA loop, the decision-making process, which came from a military background from fighter pilot training, about how people observe events, orient themselves to those, make decisions, and then act upon those decisions. And the quicker you can go through that decision, the quicker you can respond to a threat. Well, training is one of the things that speeds up that response time. Your experience, the difference between a rookie officer and a very seasoned veteran officer, the difference in experience is vast, and the veteran officer will see things that maybe the rookie officer is not able to detect yet, or that a civilian won't even notice. So that's really important. We talk about action being quicker than reaction. That's important for people to understand, because if you, as an officer, if you wait until the suspect has drawn what's clearly a gun and started to point it in your direction, if you wait until that moment, until you start to respond, you're going to lose that gunfight, right? Gunfights are not the event to come in second place. That's not a good thing. So those are kind of the allowances that we have to make for officers to be proactive. We want officers to be proactive. When we talk about action versus reaction, for example, one of the organizations that we reference all the time is an organization called the Force Science Institute. And for any law enforcement people that are listening, I'm sure they're going to be familiar with it. One of the studies that the Force Science Institute did had to do with timing, trying to quantify the difference between action and reaction. And they did this by having officers shoot one round at a target. And they timed the officers. There were specific parameters. I won't go into all the details. But basically, they told an officer to raise their weapon and fire a round at a target, and they timed the officers how long it took to do that reasonably accurately. So that was them timing action. But then they wanted to time reaction so that they could compare the two. The only difference they made was they mounted a light near the target, and they told the officer to fire when the light came on. And it took, even though the officers were allowed to start this time already aiming their weapons at the target, it actually took them longer to fire when they had to react than they did when they could move on their own. And what that brings up, and other research has supported this, it brings up the issue of the mental response time, mental processing time. When you see something happening, certainly a threat, but it could be anything in your daily life, it takes you a moment to observe it and to figure out what it means. That would be the orient in the OODA loop. And then to tell your body to react to it, even if you know it's coming. So they Force Science Institute did a good job of sort of quantifying the fact that there's that reaction that takes time. The point of that is that officers try to cheat that timeline by being proactive and being ahead of the curve. It may look aggressive to people, to civilians or people in the media, when an officer has his hand on his gun, his or her hand on their gun. It may look aggressive when they have their gun out of their holster. They may not be facing a deadly threat at that moment, but they may be seeing danger signals in the behavior of the suspect or the wording that the suspect is using that are leading them to believe that the suspect is going to be a threat. And so what they're doing by putting their hand on their weapon or taking their weapon out of their holster, for example, is they're shortening their reaction time. They're shortening their timeline. So that's very important for people to understand. And then we show some videos during the class. We do show a couple of videos from incidents where, in fact, a suspect puts his hands in his pockets. And as the officer is actually telling the suspect, take your hands out of your pockets, the suspect draws a weapon out of his pocket and shoots 2 officers in less than a second and a half. So these things do happen very quickly, but people need to understand that. And it's often hard to appreciate that if you haven't experienced it, which is why, in addition to the lecture part of our class, we always let the students take part in a virtual firearms training simulator. So get back to the bigger picture of our class. When we travel around the country and train media professionals, we always partner with a local department, a police department or a sheriff's department. And at their training academies, they often have, like you do here at the Law Enforcement Officers Museum, you have a Virtua system. There are other companies that make those, but Virtua is very good. You have a firearms simulator. And when they get to hear what we have to say in the class, and then they get to go into the simulator and have to react to the screen themselves, the big sort of video game law enforcement situation, it really makes it real for the students. It shows them how tense and how difficult it is to assess everything that's going on and to make that judgment of whether or not to use force. So another thing we talk about with regards to speed is how quickly rounds can be fired by the suspect and by the officer. So it's not uncommon for a person, certainly a police officer, but really anybody, to pick up a semi-automatic pistol and be able to shoot 4 to 5 rounds per second. So imagine that if a gunfight lasts 2 or 3 seconds and both people are shooting, you're talking potentially about 20, 30, 40 rounds that have been fired in a matter of 3 seconds. And it seems like a lot when somebody reports that an officer fired 5 times or 8 times or 10 times or 12 times. But if you don't realize how quickly that can happen, then sure, it might seem like, well, why did he shoot the suspect 12 times? Well, when you're in that sort of a situation, shooting that quickly, first of all, you don't know whether each of those rounds is actually hitting. You're not shooting a target for a score. Officers don't shoot to kill. They don't shoot even to wound. They shoot to stop the threat. They shoot to change the behavior that they're witnessing, to shoot to stop the aggression against themselves or against somebody else. So they shoot until the threat diminishes. And there have been many instances where suspects have been hit many times, numerous times, and continue to shoot back at the officer. So the officer keeps shooting. When we talked before about the reaction time, how there's that little delay between an officer or any person seeing something, being aware of it, and then having their body actually respond to it, right? Telling their body to respond. Like, for example, to really simplify this, the officer sees something, their eyes see it, their brain has to process it, and then send the signal to their hand to actually squeeze the trigger of the weapon. Well, it also takes time, and this is one of the most important things we talk about, I believe, or in my half of the class. It's one of the most important things, is that it also takes time for an officer to stop shooting. If they see that the threat has changed, for example, the suspect has been hit and is starting to drop the gun and fall to the ground, as an example. The officer's eyes see that, but it takes a moment for their brain to process it and send the signal to their hand to stop shooting. And there's research that supports all of this. So the example that we always give has to do with a traffic signal. What's the red light for on the traffic signal when you're driving? Stop, right? What's the green light mean?
Go.
Mean go. What's the yellow light for?
It means slow down.
Why?
Or because the red light's going to start, and pretty shortly after the red light turns on in one direction, a green light's going to turn on in another direction.
That's correct. The yellow light is the perfect example, the perfect way to acknowledge the fact that it takes any human being a moment in time to stop doing one thing and start doing something else. It takes a moment to see it and take your foot off the gas and move your foot to the brake and start to slow down. So we always ask the class, imagine how exciting it would be if when you drove home today, if all of your traffic signals only had red and green lights and they just instantly changed from green to red. You'd have to slam on the brakes with both feet because you know the other lane, the opposite direction is about to go, right? So the yellow light is that perfect symbol. It takes officers time to start to shoot at a threat. It takes time to stop shooting. And that means that even though a suspect, for example, may have been shot, there may be a few more rounds that are fired before the officer actually gets to take their finger off the trigger. And that happens to anybody. So we'll go on to something else. But
No worries. You've given us some really good information here, and I think the traffic light metaphor is a really good one. For some people, yellow light means speed up, but
that's true.
It's not what it's supposed to mean.
That's not what it's telling you to do, though.
That's how it feels like people act with yellow lights around here, but that's okay. To wrap us up a little bit, do you have some final words first? But I want you to think, as you're getting into this last kind of section, think of like a couple takeaways that you want our listeners to have. And I'll ask you again when you wrap up. But just while we're kind of in this kind of wrap up section,
we can kind of go back and forth here. But I would say one thing, and this is a bit of a result of some of the coverage that we've seen sometimes with these events, is for people not to mistake or confuse the reason that an officer stops somebody with the reason that they use force. So for example, if you hear, or if an officer pulls somebody over for speeding or running a red light or having expired license plates, let's pick speeding. Pull the person over for speeding. During that traffic stop, the suspect becomes aggressive and pulls a weapon, and there's a shootout that ensues with the suspect and the officer. And the officer shoots the suspect. And then people might say, and we've heard it said, well, this person was shot for speeding. Well, they weren't shot for speeding. The officer didn't use force because they were speeding. The person was contacted because they were speeding. The officer used force because the suspect presented a deadly threat. So you can't confuse the reason for the police contact with the reason for the use of force. They are two separate and distinct decisions.
I would say that one of the big things to take away at the end of the class for the people that are there and for the public to understand is while the rules for legally for using force are, again, as we've covered, reasonableness, that is based upon those objective factors and objective facts that an officer can point to. And many, many times those facts are behavior based on the part of the suspect. Jay made reference to people placing their hands in their pockets, reaching to their waistband. Those actions coupled together with additional facts that officers have, such as, I have information that this individual is armed. We received a radio call that says, hey, go to the corner of 1st and Main Street. There's supposed to be an individual there with this description that's armed with a firearm. We know as law enforcement officers that suspects often carry firearms in their pockets where they can conceal them, in their waistbands where they can not only conceal them but can quickly draw them out. So pockets and waistbands are very concerning to us. And so when we as officers come up to them and make contact with them, we're paying very close attention to their behavior. So I would say that the number one indicator as to whether an officer is going to use force, and if they use force, how much force they use in a contact with a suspect, is the behavior of the suspect. So officers are very attuned to the body language and the words that people are using when they come in contact with them.
Absolutely.
So one other thing I'd like to comment on, not so much the material in the class, but about our course, about what we're doing all together, is that we've taught this class in about 40 cities so far. And as I said, it's aimed at the media, or it's geared towards the media. And the media have been unbelievably receptive. We have met so many people across the country. It's really been amazing. I would have thought initially when we started this, I think I would have thought, and maybe a lot of other people would have too, that the media would not be receptive to this, that maybe they had their own mind made up about law enforcement. That's not what we have found. We've done this from Boston and New York all the way to LA and San Diego. We've done it from Nashville to Seattle. We've done it in Alaska. We've done it in Denver and Dallas and all over the place. But in doing that, we've learned some interesting things about the media's perspective on this. Because in the class, we start every class by giving out a little questionnaire where they can put their name and who they work for and what type of media they are, print or broadcast or online or whatever. And the most important thing we ask them is, tell us 3 things that you wish you understood better about police use of force. We're trying to understand where the gaps are. And we track all that. And so we look at the data, and the most common things that we're asked, or that the most common topics they bring up, the biggest one really is law enforcement training. And I was glancing at my numbers here because I couldn't remember the percentages precisely off the top of my head. But it's about 27% about law enforcement training. Other big issues are policy issues, legal issues, and human performance related issues. Those types of questions together only make up about a third of the questions that people ask. What's interesting is after the class, what we realize is when we ask them to finish their survey and ask them, how was the class for you? And it's not just us trying to get a pat on the back. The most important thing for us is we ask them, what are the most important things you learned? And by far, the most important things they learned had to do with legal issues and human performance dynamics. And we talk about it. We talk about policy and we talk about training. But those 2 things together, legal issues and human performance factors, each of those are about 43% each. So almost 9 out of 10 of their responses are one of those 2 things. So the reason that I bring that up is to show not only how receptive the media really are, but also because as a result of this, all the training we've done with the media, just last year, we started putting on classes for law enforcement public information officers to share with them what we've learned from the media. Because law enforcement PIOs around the country, when they're dealing with the media, we're telling them, these are the things that we have learned from coast to coast. These are the things that the media have told us that they don't understand. So make sure you're explaining this when you're having a press conference or you're talking about any other thing. Don't wait until after somebody in your department gets in a shooting to start talking about use of force. Because if you wait until then, even though you may be accurate, you're just going to sound defensive. Talk about it now. They want to understand this. Help educate them now before the incident happens so that they can better cover it when it does.
Well, this has been incredibly informative, and I think that we have the use of force simulator, the Virtua system here at the museum. We also have the driving simulator as well to kind of have that conversation with our visitors about how law enforcement officers are trained. And our use of force system especially became a very important part of our museum experience after 2020, after what happened with George Floyd and all of these other incidents that really brought use of force policies and officers having to use force on the job and how it's reported in the media really brought all of that to the forefront of public consciousness. And so we're very fortunate to have this system. And I think that our visitors get kind of a 20-30 minute spiel about officer use of force, but you guys coming here today and being able to kind of talk about that more in depth gives us now a resource that we can say, hey, if you enjoyed what you were learning in the simulator, if you want to know more, here's this great podcast episode with Paul and Jim. And this is a great amount of information, but yes.
If I could also say to anyone out there listening, if you're part of a media organization and you want training for your people, or if you're a public information officer with a law enforcement department and we can help, we've done these presentations for PIOs, we've done them for media, please contact us.
Absolutely. And that was going to be my next question. How do they get a hold of you if they would like to hear more about your training?
If they were to reach out to their local ATF office and ask for the public information officer, that public information officer can clearly get them in contact with me. Obviously, still with ATF. I've got my ATF email address and phone numbers that everybody in the agency can look up and reach out to us. Though through Jim's relationship as our prior SOD PIO, he's already got a relationship with most of those people. But yeah, through the agency's PIO in their local area.
That's perfect. And you guys queued that right up. I really appreciate it. So as a final, thank you so much for being here and taking the time to talk with us today and share what you guys know that really relates to what we're doing every day on the floor. We really appreciate you guys coming and taking the time. To all of our listeners, we thank you for tuning into this episode and spending time with us today. If you find yourself in Washington, D.C., be sure to visit us at 444 East Street Northwest. We're open Thursdays, Fridays, and Saturdays from 10 a.m. to 5 p.m., and we'd love to see you. So until next time, stay safe, and we'll see you all again very soon.
Please subscribe to Precinct 444 on your favorite podcasting platform to stay connected and to receive our latest content as soon as it drops. We would love to hear from you. Send in your questions, comments, and feedback to precinct444@nleomf.org. You can help us make our content even better. The National Law Enforcement Museum is located at 444 East Street Northwest in Washington, D.C., and is dedicated to telling the story of American law enforcement. We expand and enrich the relationship between law enforcement and the community through educational journeys, immersive exhibitions, and insightful programs. Find us online at lawenforcementmuseum.org and stay tuned for more podcast content from Precinct 444. Until next time, stay safe. We'll see you at the Precinct.